Anthropic built its reputation on safety and ethics, but a 2024 court filing revealed a contradiction at the heart of its technology: a secret internal library built from over 7 million pirated books. While a judge found the asterisk training and margin tie-in of its AI model to be fair use, the act of stockpiling the books themselves was not. This single distinction triggered Anthropic's $1.5 billion copyright reckoning. The case moves beyond abstract arguments and forces a more fundamental question. What is the true cost of the raw material used to build artificial minds? To understand the $1.5 billion price tag, you first have to understand the value of what was taken: the intellectual property of thousands of authors, protected by federal law, representing decades of painstaking craft. The legal dispute shifts the focus from Anthropic's algorithm to the raw material it consumed. At the heart of the class action are the owners of approximately 482,000 distinct copyrighted works. These are not merely books. They are a specific asset class protected by federal law, each representing a significant investment of labor, creativity, and economic risk. The U.S. Copyright Act grants creators a bundle of exclusive rights, with the most fundamental being the right to control reproduction. This legal shield is the economic engine of the publishing industry, allowing authors to be compensated for their work. It transforms a creative act into a viable profession. This solitary human-scale craft stands in stark contrast to the mechanics of large language model training. The painstaking process of writing, editing, and refining a text is measured in years. Data ingestion, conversely, is an automated industrial process measured in petabytes and processing cycles. The lawsuit alleges that in this collision of scales, the foundational right of reproduction was systematically violated. For an AI to learn from a text, a copy must first exist on a server. The plaintiffs contend this essential step was performed without license or payment, on a massive scale. This creates a critical question of provenance. If the value of the asset is established and the alleged violation is unauthorized reproduction, the legal path forward depends on identifying the source. Abstract value requires a specific, tangible origin. Unlike traditional publishing disputes, this case does not hinge on a broken agreement or a betrayal of trust. There was no pre-existing relationship to violate. The conflict's origin, according to the plaintiffs, is an act of non-consensual acquisition from a source operating entirely outside the legal framework of copyright. The core allegation is that Anthropic's training data was not licensed, but harvested. Court filings point to the alleged origin: sprawling digital archives known as shadow libraries, specifically naming sites like Library Genesis and Pirate Library Mirror. These platforms function as vast, unauthorized repositories, offering millions of copyrighted texts for free download. They represent a systemic circumvention of the entire intellectual property ecosystem, operating without permission from authors or publishers. This is not a transaction, it is an extraction, exploiting the digital environment's vulnerability to mass duplication and distribution. The abstract illegality of a pirate website, however, is not what triggered a potential $1.5 billion liability. The critical legal step, as outlined in the complaint, was Anthropic's alleged decision to copy and preserve the contents of these libraries, over 7 million books, within its own internal servers. This transformed a diffuse, external problem into a concrete, internal liability, creating a searchable corporate asset from illicitly obtained material. The question was no longer about what existed on the internet, but what now resided inside the company. The legal case pivots on a single, devastating distinction, one a federal judge would articulate with surgical precision: training an AI model on copyrighted works? Potentially defensible as fair use. But copying over 7 million pirated books into a permanent, searchable, internal, central library? That was an entirely separate act. And an allegedly unlawful one. This wasn't a transient training blob that passed through memory and vanished. It was a warehouse. Persistent. Analyzable. Corporate. That single strategic choice, the decision to save rather than merely ingest, proved to be Anthropic's critical vulnerability. It collapsed a nuanced, theoretical debate about AI learning into something far simpler: mass reproduction, and possession of stolen goods. The plaintiffs no longer had to argue that Claude had learned from their work in some impermissible way, a philosophical puzzle that could have kept courts tangled for years. They only had to point to the files, 7 million of them, sitting on Anthropic's servers. The company wasn't just accused of using illicit data. It was accused of building a library out of stolen books, the kind of thing that, in the physical world, would fill a federal evidence locker to the ceiling. With infringement now anchored to a concrete, documented act, the entire nature of the litigation shifted. The debate was no longer philosophical. It was arithmetic. The central question became brutally simple. What is the price for 7 million pirated copies? The $1.5 billion figure does not represent a punitive fine, but a negotiated settlement designed to quantify the liability of the Central Library. The proposed financial structure transforms mass infringement into a manageable corporate expense. Anthropic has already paid an initial $300 million, with 2 additional $300 million installments and a final $450 million scheduled for payment after preliminary approval. This plan converts a potentially existential legal threat into a predictable, if substantial, line item. The total award is to be distributed proportionally among the owners of approximately 482,000 eligible works, with plaintiffs, attorneys estimating a potential payout of around $3,100 per work before costs. Yet, this resolution faced immediate friction. During the approval hearing, the presiding judge pressed for details, scrutinizing the proposed attorney fee of $187.5 million, or 12.5% of the fund. This judicial oversight highlighted the inherent tension between lawyer compensation and the direct recovery for class members. The settlement's perceived inadequacy was further exposed, as more than 25 high-profile authors opted out entirely. By rejecting the deal and filing a parallel lawsuit, they challenged the premise that this mass payout constituted fair justice. Their dissent reframes the historic settlement not as a definitive victory, but as a contested, compromised peace. Anthropic faces a new dilemma. Even after securing a billion-dollar agreement, its legal exposure from the library is not fully contained. The Anthropic settlement doesn't just close a case. It redraws the legal map for every AI company that ever scraped the open internet. The precedent is now etched in federal record. Risk no longer hides inside the black box of a neural network. It sits in plain sight, on the servers, in the file structures, on the hard drives where pirated works were stored and cataloged. The court drew a bright line between the act of training and the act of stockpiling. That central library of 7 million illicit works was not a research tool. It was a warehouse of infringing copies, and its existence, not the learning it enabled, but the hoarding itself, was the violation. This redefines corporate compliance from the ground up. The new mandate is clear: rigorous data provenance, verifiable contractual hygiene for every training corpus. Anthropic's own commitment to destroy the original downloaded files within 30 days of a final judgment is more than a concession. It is the industry's first documented procedure for cleaning house. The era of grabbing vast, unvetted datasets and asking forgiveness later is closing, punctuated by what is now the largest known copyright settlement in United States history, $1.5 billion, a number that will be cited in every AI licensing negotiation for the next decade. A company's data lake has become as auditable as its financial ledger, maybe more so because the plaintiffs' bar now has a proven playbook and a proven price tag. But the real question hasn't been answered yet. As the court scrutinizes fee structures and payout mechanics, the granular economics of compensating 120,000 authors across 482,000 works, a deeper fault line emerges. The legal system built the liability framework. The next wave of litigation will test whether it can build a fair one. Will the courts now move beyond simply establishing who's at fault and start dictating the economic fairness of these mass-scale digital settlements? Because if this precedent holds, every AI company's training pipeline is no longer just a technical asset. It's a contingent liability, measured in billions.